Thanks everyone for joining Landmark Chambers webinar on immigration detention challenges, and in particular immigration detention challenges under the COVID-19 crisis. We're really pleased to be doing this. Graham, Denholm and I, obviously involved in doing immigration detention cases for a long time, and both of us have been quite involved in particular over the last month or so in a number of challenges to detention around the time of COVID-19. I guess the motivation for this, and this is not going to be a particularly lengthy set of talks. It's just to give you, hopefully, or share some of the kind of benefits of our experience of doing those cases in these slightly unusual times, and also just basically what we've learned doing them in terms of, for example, Home Office practice and policy, because even where the Home Office has published its policies, the specific policies relating to COVID-19, they're not easy to find. They're not accessible in the normal way. One doesn't quite know where to look, and obviously things have been developing very rapidly. So we hope you'll find it useful. I'll hand over shortly to Graham, who's going to give the first presentation. Just a few quick housekeeping points. Your microphones are automatically muted, and I don't think you can change that. That's obviously just because we've got 160, 170, possibly 300 people on the thing, so it become unmanageable otherwise. Your videos should have been turned off when you joined. You can turn them on, but I think we'd ask you not to. A, it will challenge the bandwidth, and B, it's just going to get a bit confusing if there are lots and lots of faces, much as we'd like to see you all. We will take questions. You should have access to a chat function, so please ask questions via that. We'll do our best then to answer the questions at the end. Obviously, if there are thousands of questions, we won't be able to deal with them all. We'll do our best. And Graham in particular is going to be looking at questions on his own talk and mine whilst I'm giving my presentation. The webinar is recorded. The slides and the recording will be uploaded to the Chambers website. And if you have a problem with the connection, do just please rejoin as you can. As I say, it will be available online later on, hopefully today, but certainly by tomorrow. I'll hand over to Graham. He's obviously the great expert in this field. He's the author of the main textbook on immigration detention, and he's going to be kicking off by talking about the Detention Action Challenge, and then some of the other cases that have been going on in the last 4 to 6 weeks or so. So over to Graham. Thank you.
Thank you, Tim. I hope everyone can see and hear me. Tim, do jump in. It looks like there's any issue with the tech. So yes, I'm going to be looking at the decision in Detention Action Ravin and the Secretary of State for the Home Department, and a few subsequent cases that cast some light on the way the issues arising from that case are being dealt with in its aftermath. The Detention Action Challenge was the first major piece of litigation, the first sort of test case to emerge out of the COVID-19 pandemic. It was a challenge brought by Detention Action and an individual claimant, Mr. Ravin, against the whole practice of continuing detention in the face of the pandemic. So sort of broad-reaching claim seeking very wide-ranging relief. It was issued on the 18th of March, and it was in court for the interim relief hearing. It's the interim relief judgment that we have and that we'll be discussing. The claim itself remains live a week after that, the 25th of March. It was, as I say, it was characterised as a challenge to the ongoing detention of all immigration detainees in the face of the pandemic, together with a separate application for release from Mr. Ravin himself, Mr. Ravin being a Lithuanian national facing deportation, having been convicted of offensive arson. The broad challenge was framed as an allegation of a failure by the Secretary of State to inquire into each detained case in light of the changed circumstances arising from the pandemic, breach of the duty to maintain a safe system of detention, breach of the protection duty under, and a breach of the protection duty under Articles 2 and 3 of the European Convention. and the sort of generic basis of the claim was framed in part by reference to very detailed expert evidence from Professor Richard Coker of the London School of Hygiene and Tropical Medicine, examining the impact of a pandemic of this type in what was termed congregate settings, such as immigration removal centres, and dealing with the impact of infection on vulnerable individuals, amongst other things. By the time the matter came before the court on the 25th of March, matters had moved on somewhat from the way they did when the claim was first formulated. Interim release was refused, as we'll see in a moment. In reaching its conclusions, the court noted 6 factors to which it attached particular weight, 6 groupings of factors, as it were, that the Secretary, in terms of steps taken by the Secretary of State to deal with the pandemic in the immigration detention state. The first was steps, broadly speaking, taken to make the detention state safer, so guidance on hygiene, increased heightened cleaning standards, making cleaning materials available, devising plans for isolating at-risk detainees, curtailing in and out of IRCs, and so forth. The second was to minimise the numbers of people coming into the detention state. It was said at the time, and Tim will deal with where we've reached in terms of the policy position, but at the time it was said the Secretary of State would not be detaining anyone from a country to which removal was not possible by reason of the pandemic unless they posed a high risk of harm. At the same time, they were taking steps to reduce the number of people in detention, and that number had reduced from 1,200 to 736 by the time of the hearing, and reviews of detention were ongoing at the time of the hearing, prioritising people who were known to have factors that put them at particular risk from COVID-19 infection, and treating people who were at risk as being at risk under the adults at risk policy. The fourth was taking steps to protect those who were at increased risk if they were not released from detention. The fifth was a broader review of detention for people who were not at heightened risk, applying the Hardy-Singh principle, taking account of whether the proposed removal was to a country that wasn't accepting returns. And the sixth was guidance on isolating detainees who were showing symptoms of COVID-19 infection. The combined effect of 2, 5 was that the Secretary of State was taking steps to reduce the number of people in detention, and the combined effect of 4 and 6 was that risks were being, court risks were being addressed for individuals who were not being released. In light of those changed circumstances, the application for interim relief was reframed. The key relief that was sought by the time of the hearing was in order that any individual who was from a country that wasn't accepting returns and didn't pose a high risk of harm be released. Interim relief was refused, and just looking very briefly at the reasons that were given for that, I think it's relevant to note, I've certainly had this cited in cases in which I've been involved subsequently, that the court stressed that what it considered to be a particularly high threshold for interim relief in the circumstances of that case, in part because the relief sought was a mandatory order, an order requiring the Secretary of State to do something rather than permitting the Secretary of State, as it were. And the second was that the relief sought, although characterises interim relief as effectively final relief, once somebody's released, the Secretary of State's not to fight the JR and then re-detain them if she wins. So having characterised the test in that way, the court went on to refuse interim relief. It attached particular weight to the exceptional nature of the circumstances that were facing the Secretary of State, and the fact that on the evidence that was before the court, the Secretary of State was taking steps to deal with the continued detention of the individuals who had yet to be released. The court found nothing unlawful in prioritising the higher risk cases, and if the consequence of that was that lower risk cases had to wait for a longer period, then the court's view that was acceptable. And even if the court was wrong in its view of what the law required, it still took the view that the balance of convenience favoured refusal of interim relief. So far as the claim under Articles 2 and 3 of the Convention was concerned, the court gave that pretty short shrift. It said it didn't raise a serious issue to be tried. The the steps taken by the Secretary of State to address the issues that arose, the concerns that had been raised by the expert evidence. But for purpose of cases going forward, it's important to note what's said at paragraph 25 of the judgment. Although the court was of the clear view that the Article 2 or 3 threshold wasn't met, they nevertheless accepted that individuals in detention congregate setting are exposed to particular risks arising from that setting. So although there's not a trump card Article 2 or 3 point arising from the congregate setting issue, the court did accept that risks arise, and those risks will be relevant to the broader question of whether detention is reasonable under the Hardy-Singh principles, even in cases that don't involve people who are themselves at heightened risk from COVID. The second claimant's interim relief application became academic because the Secretary of State had agreed to release him, but it's important to note that the court made pretty clear that it wouldn't have granted interim relief had it been required to decide the issue. And anyone contemplating an interim relief application would do well to study what the court says at paragraph 29 and be ready to meet any point that's taken arising from that. Taken on the basis of that, sorry. And one final point arising from the judgment was that the court stressed, I mean, these are points that apply in judicial review litigation and urgent judicial review litigation in particular at the best of times, but it stressed that in present circumstances, it was critical that representatives who bring claims prepare the claims cogently, conduct the litigation sensibly, proportionally, that the parties cooperate with each other when bringing cases before the court. And I'll come back and touch briefly on the implications of that at the end, but those factors which apply in all cases are of particular significance at present. So moving on briefly to look at a few cases that we decided since detention action. I'm going to look at two decisions on interim relief, one substantive JR decision that's yet to be reported in a case that which Tim acted, and one slight wildcard, a decision of the Criminal Division of the Court of Appeal, in which there are some interesting comments that may transfer across, particularly to the Hardy-Singh context, looking at bringing detention challenges in the current climate. So the first case I wanted to look at is a case called Zalis. That's an interim relief application, but the judgment's reported on Westlaw at the reference given on the slide, decision of Mr. Justice Saini. It's a case involving an EU national with a conviction for rape dating back to 2001, various other convictions as well. He was facing deportation. His appeal against deportation had been heard but not determined. It was possibly going to be, the outcome of the appeal was possibly going to be delayed as a result of the pandemic. There was a Rule 35 report which made clear he had multiple health problems, including health problems that put him at risk, at particular risk from COVID-19, and it was accepted that he was an adult at risk at level 3 under the policy, but the Secretary of State nevertheless decided to maintain detention. The case was argued both by reference to the third Hardy-Singh principle and by reference to the adults at risk policy. Under Hardy-Singh, it was said that the pandemic effectively created an insurmountable obstacle to removal, and that, together with the impact of detention on his health, meant that detention was unlawful. And it was argued that given what was accepted in relation to the Rule 35 report, the impact on his health, his continued detention couldn't be justified. Mr. Justice Saini was not persuaded to grant interim relief, but refusing interim relief, accepted the urgency of the issues that arose and ordered a very urgent, granted permission and ordered a very urgent substantive JR hearing for a period of about 2 weeks. And in the event, the claimant was released, so the substantive head. The next is a case called E. Again, an interim relief decision, a decision of Mr. Justice Swift, who was one of the judges in the Divisional Court that decided the Detention Action case. It was a case involving a Greek woman who'd been a victim of serious crime, victim of kidnapping, sexual assault in the UK, and subsequently herself committed a number of offences related to drugs. She was facing deportation, but there was also an ongoing issue as to whether or not the Secretary of State was going to recognise her as a victim of trafficking. Negative reasonable grounds decision that the Secretary of State had agreed to reconsider, and that reconsideration going. It was submitted that she was an adult at risk under the guidance as a victim of trafficking, as a victim of torture, and due to a heart condition which put her at risk from COVID-19. And in terms of the court's reasoning, as recorded in the brief Westlaw summary, was only the trafficking issue that gained any traction in the court. The fact that she was a victim of torture in itself, under policy in the court's view, didn't compel release. And on the particular facts of the case, the heart condition warranted further investigation, but also in itself didn't compel release. The court accepted that the likely delay resulting from the NRM reconsideration and the real prospect of showing at trial that detention was in breach of policy because she was a potential victim of trafficking meant that the balance of convenience favoured release, but strictly on the basis that she would only be released to accommodation provided by the Salvation Army. The third case is a case called Bellow and the Secretary of State for the Home Department. The interim relief judgment of Mr. Justice Chamberlain is reported on Bailey. Final substantive judgment of Mr. Justice Johnson is not yet reported, but I've seen a transcript of judgment helpfully prepared by the claimants team, from which the approach of the judge is clear. That was an unusual case involving a Nigerian national with very serious mental health problems who'd been convicted of very serious offences in 2009, rape and kidnap. A hospital order was imposed, but the judge had made clear that had that disposal not been appropriate, a life sentence would be justified. He'd been discharged into the community in June of 2018 and then detained in December 19 pending removal. Removal directions were cancelled on various occasions through no fault of the claimants, and the most recent cancellation had been because of the suspension of travel to Nigeria in the face of the pandemic. He suffered from physical ill health, including type 1 diabetes, which is a recognised comorbidity putting people at heightened risk COVID-19. He'd been advised to shield in detention, but as I understand it, declined to do so. And the case was argued by reference to Hardiel Singh 2 and 3, the adults at risk policy, and under Articles 2 and 3 of the Convention. I'll skip over what was said at the interim relief stage, but moving on to the final decision of Justice Johnson. By that point, the Secretary of State's position had the Secretary of State had sort of retreated to a position where she was only arguing for a very brief extension of detention to be permitted, effectively to allow her to reassess risk, which had been assessed, the risk of harm to the public, which had been assessed as low. The officials reviewing detention took that was surprising to the nature of the offence that had committed and wanted a chance to revisit that. The judge referred to operational instructions that said that individuals who were identified as being at risk from particular risk from COVID under the public health guidance should be treated as adults at risk at level 3. Tim will deal with that in more detail shortly. By the time of the substantive hearing, it was common ground that the claimant was an adult at risk at level 3. And the Secretary of State, in the absence of any evidence, was unable to displace her previous assessment that the claimant posed a low risk of harm. The judge accepted there was a real and significant risk of absconding, but concluded that despite that, detention was incapable of rational justification under the adults at risk policy and also breached the third Hardiel Singh principle, and that removal within a reasonable period is not possible. The rolled up hearing, permission was granted and ordered. And then the final case that I just wanted to touch on very briefly is a decision of the Criminal Division of the Court of Appeal in the Crown and Manning. And the context for this, that everyone will be well aware, is that under the sort of the Hardiel Singh jurisprudence, Lumber at paragraph 104 is one example. It's trite that the conditions in which a person is detained, the effect of detention, are relevant to what a reasonable period of detention is likely to be in a given case. So this was a criminal appeal looking at sentencing in the context of the pandemic. But the final two paragraphs look at the relevance of change in circumstances in prison as a factor that has to be borne in mind in the sentencing context. And you'll see from the quote on the slide here, Court of Appeal says the current conditions in prison represent a factor which can properly be taken into account in deciding whether to suspend a sentence. Judges and magistrates can and should keep in mind the impact of a custodial sentence is likely to be heavier during the current emergency. Those in custody are, for example, confined to their cells for much longer than would otherwise be the case, 23 hours a day, unable to receive visits. They and their families are likely to be anxious about the risk of transmission. Those are all factors that can properly be paid in aid of the Hardiel Singh challenge, and judgment in my view the way that it's framed. So just pulling a few strands together from the detention action case seen in the context of what came after, I'd make the following 4 points. First, that the extra time permitted to the Secretary of State in the detention action case has long since passed, so that's going to cut very little ice going forward. The second is the proportionate approach to litigation that's required in light of that judgment does not in any way prevent urgent claims being brought and expedition being sought on appropriate fact. The third is that risks to health are clearly relevant both to people who have COVID-19 comorbidities and more generally. And the fourth is that it's self-evident that the pandemic will have an impact on the timescale to removal, and that will feed in the Hardy-Singh arguments, as can be seen in cases. So with that, I'll pass over to Tim.
Right, hopefully you can see me. I'm now just going to take over. Yeah, so share my screen. Right, so hopefully you can now see the first title of the title page of my slide. It did occur to me that these seminars are an opportunity to compare sort of the effect of lockdown haircuts, although I think I've brought it slightly under, compared with the sort of before photo you have in front of you. Although I think I managed to bring it slightly under control compared to this morning. Anyway, right, so I think I'd just say I agree with Graham's observations, especially at the end there. I'll touch, and I don't think that the detention action case should be taken as any kind of, although the Home Office has tried to argue that it is, but shouldn't be taken as any disincentive to bring cases on behalf of claimants at the moment. Just pulling back, before we get into the policies, why is there a big issue about immigration detention and COVID-19? Well, I think there are two critical, they may be blindingly obvious, but two critically important points in terms of why the legality of almost everyone in detention is at any rate up for grabs as a result of this crisis. The first is that once we've got this COVID-19 crisis, removal is likely to be impossible, and is not, in all but a tiny number of cases, I think, is not occurring in the short term and possibly the medium term. And as you get into the medium and even the long term, obviously the prospects of removal of immigration detainees is highly uncertain at best, maybe in the very, very long term for the sorts of people who it might be legitimate to detain for years on end. Maybe it's not such a big effect, but for most people, it's a big deal. And of course, it's a reason that they can't be removed, which is out of their control. So the government can't say, well, we're detaining people who can't be removed, but it's their own fault we can't remove them because they're not cooperating with the removal process. Well, that's just not relevant. That's the first point. And that's going to massively affect whether it's legitimate to keep detaining people. The other point is the one that Graham's already touched on, which is that as the court accepted in the detention action judgment, people in immigration detention are, by virtue of that very fact, and even if the government has in place some shielding measures or measures to keep detention centres relatively safe, people are at a higher risk of contracting COVID-19 because there are just difficulties in managing the detention centres, managing self-isolation, that sort of thing in detention centres, which don't arise for people who are staying in their own accommodation. So for those two reasons, immigration detention is called into question for most people, and we need to see, first of all, what policies the government has put in place to deal with that. I should just say my talk is supposed to be include tactical considerations. I'll touch on those at the end and some of the kind of practical experiences of bringing litigation. I've got less time to deal with that, so but if people want to ask questions about that, and we can sort of expand that out via the questions, that would be great. Okay, in terms of policy then, it breaks down really into, well, first of all, let's just identify what the pre-existing policies are and how they apply. And secondly, what are the new policies, if any, that the government has put in place? So obviously the critical policy for all immigration detention is in Chapter 55 of the EIG. Contains, I've given a link for those who aren't familiar with it, but I suspect many of you are. Presumption in favour of release for all detainees, including foreign national offenders. It no longer contains the policy dealing with vulnerable adults. We'll come to that in just a moment. And last bullet point on this slide, what is the relevance of Chapter 55 to the legality of detention? Well, twofold. First of all, it seems to me that some of the bits I'm going to be looking at on the next slide can at the very least be used to inform the Hardy-Singh assessment. So you may be dealing with, as I was in both Bello and Zales, for example, with judges who are perhaps, certainly one of the judges, relatively new to immigration detention. And it's quite difficult to calibrate. It's quite difficult to work out, well, what is a reasonable period? Is 2 weeks reasonable for someone with no offences? Is 2 years reasonable for someone with offences, etc.? Of course, it all depends on the detail of the facts, but the policy can help guide that, and is actually, if applied properly, can be surprisingly helpful. Secondly, can you argue that detention is unlawful by breach of the policy? Well, you certainly can in relation to the adults at risk policy, but the limitation on doing that with the bits of the policy I'm going to be looking at it on the next slide are that really it's just replicating the court's role under Hardy-Singh. So query whether the court's ever going to say it doesn't breach Hardy-Singh, but it does breach the Home Office policy on Hardy-Singh because they haven't applied it properly. It's difficult to see what that would add to Hardy-Singh. Anyway, what are the relevant bits of the policy? Well, I do think it's worth looking at these, even if they're familiar. In particular, there's, as I'll say in a moment, almost everyone detained now is likely to be a foreign national offender. There's a detailed part of the EIG policy which deals with the detention of foreign national offenders. And there are a couple of things which I think are worth really being aware of and can be used as part of your armoury or your arsenal in terms of attacking detention. So first of all, imminence is defined, and the policy says that for foreign national offenders it will usually be appropriate to detain people for whom removal is imminent, but certainly you can say pretty categorically that removal is not going to be imminent for most of those in immigration detention at the moment. Why? Well, because the definition is where a travel document exists, removal directions are set, there are no, I think that should be no, not, there are no outstanding legal barriers, and removal is likely to take place in the next 4 weeks. Well, I wouldn't have thought that that could be said to be true for anyone at the moment who's detained under immigration powers, and it will certainly be a wholly exceptional case. And so you've got quite a useful starting point, and that will play into the adults at risk policy, as we'll see in a moment. Risk of harm, I just draw attention to this because often the Home Office will assess risk of harm much higher than it is assessed by, if you like, the professionals. So, for example, the National Offender Management Service, whether in OASIS reports or pre-sentence reports, or, for example, in the Bello case that Graham touched on, which I argued, he had been assessed as being of low risk by the Mental Health Review Tribunal, who are expert in the assessment of risk for those sorts of people. And the Home Office at certain points accepted that, but at some other points didn't. So the point is, the EIG policy, although often ignored by the Home Office, places emphasis on those professional assessments of risk. The Home Office really oughtn't to be going off and doing their own assessments. That then feeds through in EIG 55 3.2.10, sorry about all the sub-paragraph numbering, into a table which enables you to produce, or enables the Home Office to produce, an overall risk assessment for an individual. And the reason why that's so helpful is that paragraph 55.3.2.11 then recommends effectively release for people who are not assessed as anything other than high, so low or medium offenders. If their removal is not imminent, are recommended for, this is not absolute, but are generally thought appropriate for release. Now, why is that useful? Well, it's useful in itself, but it seems to me it's a really useful starting point when you're thinking about the additional measure, additional support for release you can get from the adults at risk policy, which I'll come to in a minute, because you're entitled to say, as we submitted in both Bello and Zales, that, look, even without regard to their special vulnerability, these are for detainees who are not specially vulnerable by reason of COVID-19 or mental illness, even without that, this is a person who the policy contemplates release for. And that ought to be your starting point when you turn and look at the cumulative impact of the AAR policy. So the other pre-existing policy then is the adults at risk policy. It contains a presumption of release for those vulnerable within the meaning of the policy. We'll see what that is in a minute. I think it's really important to emphasise, the policy doesn't spell this out, but it must be right, that that's an additional presumption of release, which is distinct from the presumption in favour of release, which applies to all detainees in the EIG. Who is a vulnerable adult? They're a person who has a condition or they've experienced a traumatic event, so condition, traumatic event, that would be likely to render them particularly vulnerable to harm in detention. Obviously, this will be relevant to people with mental health conditions or experience of torture or that sort of thing, which makes them more vulnerable. It's not in and of itself note that they will suffer harm, it's that their underlying health condition or their past experience simply makes them more vulnerable to harm. That is sufficient to engage the policy. And you then have the 3 levels. So the presumption in favour of release is progressively stronger. I'm sorry, I think I've flicked a slide by mistake. Presumption in favour of release is progressively stronger according to whether you're level 1, level 2 or level 3. But as I say in the bullet point, the 4th bullet point on this slide, there's an oddity about this policy, which I think is worth thinking about. I mean, it hasn't proved a problem in the cases I've been doing on COVID-19 so far, but I think the more I think about it, the more I think this is a flaw in the policy which perhaps ought to be challenged in an appropriate case, is that the level 1, level 2, level 3 is entirely by reference to the quality of evidence. It's not to do with the seriousness of the condition or the likely harm that will occur. So one of the paradoxes I felt in some of the cases I was doing is that I had my client, Mr. Bello, had a particularly serious mental health condition, but he was being managed by medication, and that it was quite well known how he could be managed. But his condition was particularly severe, whereas another client that I had with a not by any means minor, but much less serious mental health condition, was treated as level 3 because although his condition was much less serious, and although frankly the likely harm might have been less, on the other hand, a GP had said, well, he's likely to deteriorate. So there's a kind of lack of subtlety or lack of flexibility there about the policy. Anyway, the presumption in favour of detention can be in favour of release, I should say, can be overridden by immigration factors, and the policy in and of itself gives very little guidance on how the balance should be struck in terms of balancing out risk of harm and to the individual and risks if they're released. So how do you and so that's one of the further flaw in the policy, but it is supplemented, and here I think we can get something of substance, by the caseworker guidance. That gives further guidance on how the immigration factors should be balanced against the presumption in favour of release. So immigration factors, I should have said, mean basically risk of harm by reason of reoffending and risk of absconding. And the guidance on level 1 and level 2 can be useful, it's worth being aware of. Of course, this is all guidance you can use, as it were, against the Home Office. In all of these cases, this is guidance which says that the person should be considered for, not that they should be detained if these factors aren't present, but they should be considered for detention if these factors aren't present. So they should only be considered under level 1 if the date of removal can be forecast with some certainty and there's a reasonable timescale. I mean, that doesn't tell you very much, but you can make something of the forecast with some certainty point. Level 2, slightly more specific, considered for detention only where the date of removal is fixed or can be fixed quickly, but alternatively where there's a high risk of harm. There's a bit of a get out for the Home Office there because you're back to the kind of general balance, and the policy doesn't tell you very much how you strike that balance. But the guidance on level 3 is, I think, genuinely useful for claimants. So level 3 should be considered for detention, not detained, considered for detention, either where removal has been set for a date in the immediate future. And just pause and think about how that interacts with the EIG policy on imminence. It seems to me that must mean something at least as strict as the removal is imminent. And it seems to me probably means something much stricter. I mean, that removal is going to take place very quickly indeed and is pretty much certain. Or, and this is going to be critical in a lot of these cases, the individual presents a significant public protection concern, or if they have been subject to a 4-year plus custodial sentence, or there's a serious relevant national security issue, or the individual presents a current public protection concern. Now, we had quite a bit of debate about what all of that meant in front of Mr. Justice Johnson in the Bello case. Unfortunately, the transcript of the judgment is not available. We're reliant on the note and my recollection of it for now. But a couple of points to note. First of all, there's a lot of overlap here. So what's the difference between a significant public protection concern, the first bit, and a current public protection concern? Well, my opponent pretty much conceded, and I think the judge thought that they were the same thing. They didn't really add anything. National security cases, well, okay, those are different. They're in a class of their own. And then the other bit, which was important in Bello and is likely to be important in a lot of these cases, is if they have been subject to a 4-year plus custodial sentence. Because certainly judges have been concerned about the idea that that means that even if you've got an individual who is a low risk of harm, as my client was in Bello, Mr. Bello was, for example, and as we certainly said Mr. Zallis was, that nevertheless they shouldn't be being, they can be detained on the basis of merely on the basis that they've only been detained for, that they were sentenced to an offence which carried more than a 4-year sentence. So we had a debate about that, and the judge accepted my argument, and to some extent it's fair to say concession of Home Office counsel, or at least he didn't press against it, that this is just a gateway. So you can consider someone for detention in those circumstances. That's a trigger, if you like, for thinking about whether they present a serious public protection concern. But the mere fact that they have a past history of serious offending of that kind is not in itself a reason to detain them, let alone a reason to detain them under the level 3 adults at risk policy. You've got to be satisfied they actually present a current public protection risk. Now that seems to me to follow from Hardiel Singh. It follows from what is a relevant factor in immigration detention cases, see Lumba, but it's useful to have it spelt out in the specific context of this policy, it seems to me. The other thing that's really useful about the caseworker guidance is what it says about level 3 and compliance. So compliance means of risk of absconding. It says very unlikely that compliance issues on their own would warrant detention of individuals falling into this category. In other words, a Home Office shouldn't be seeking to justify detention on the basis of an absconding risk, or principally on the basis of an absconding risk, once it's concluded that a person is at level 3 under the policy. And that was the basis on which Mr. Justice Johnson in Bello concluded that not only was there a breach of the Hardiel Singh principles, but it was simply irrational for the Home Office to keep detaining him in circumstances where he was a low risk of offending. And we said low risk of absconding. He didn't. The judge didn't accept that, but I don't think he found him to be at high risk. But anyway, not absconding can't justify detention under level 3. So those are the pre-existing policies. What about the new policies? Well, there are two which are really useful to be aware, one of which is really useful and one of which is deeply disappointing. So first of all, thinking back to what I said at the outset about what are the relevant reasons why COVID-19 is so important to detention? Well, first of all, vulnerability, risk from being in detention. The government has published now, the Home Office has now published the guidance which I've given a link to in the slide, which is about the operational guidance about the adults at risk policy in COVID-19. And certainly for those who have one of the relevant comorbidities, so asthma, diabetes, anything of that, and there's a list which you can access here, they must be treated as level 3 under the policy. And that you can immediately see why that, coupled with what I've just been saying about the caseworker guidance, then becomes a very important and very powerful tool in terms of securing release and in terms of arguing that detention is unlawful. Because if you've got a client who is anything other than a high risk of reoffending, high risk of reoffending and of serious harm, then you're going to be entitled to say that that policy mandates or comes close to mandating release. What about now? The real problem about this policy is it seems to be being ignored. It was declared to the court in detention action, but my experience is that caseworkers are not being made aware of it. So in the Bello case, his detention was reviewed in early April, and it was just, even though they accepted he was in the shielding camp, but they ignored it. They denied the existence of the policy, or at least were not aware of the policy when the interim relief matter was argued. And I suspect that the same thing will have been happening. So that may mean that in practice a lot of people are being unlawfully detained because the policy isn't being applied. Anecdotally, suggests that may be the case. This policy is less clear-cut when you've got someone who's not got one of the main comorbidities. but it seems to me it does provide room to argue at any rate that even for people without one of the specific comorbidities, even people with no particular underlying health condition, that the danger arising from COVID-19 at any rate engages the adults at risk policy, but there's no judgment on that yet. What about the other issue, removability? Well, as Graham touched on, the government announced that it had to the court in Detention Action that it had a policy about countries to which removal was impossible. And I quoted from the judgment: "The Secretary of State has decided she will not exercise her power to bring into detention persons liable to removal from the UK to countries where removal is not possible by reason of COVID-19, which was then about 50 or so countries. So unless, I should say, unless the person concerned is considered to present a high risk of harm to the public." So there's another policy which effectively says, well, you shouldn't be detaining at all unless there's a high risk of harm to the public. But unfortunately, the position on this is very unclear. First of all, as expressed there, and as it was expressed, there's no clear policy text for this, unlike the previous policy. And as it is expressed to the court, and as it was expressed in some of the internal policy internal emails that I've seen from the Detention Action judgment, it only applies to new detainees. So it's not simply not relevant, this policy, to people who are already detained as at 22nd of March or mid-March 2020. It seems to me that's arguably irrational, and I believe that the claimants in Detention Action sought to argue that it was irrational, because after all, first of all, what's the difference? And secondly, if there is a difference, it seems to me that the people who are already detained have already been detained for a period of time. They're that much closer to the end of the reasonable period, and therefore, if anything, the policy should benefit them more, not less. But anyway, that's the government's position. But there may be room to argue about it. Secondly, it doesn't look like it was ever updated. In Bello, we pressed for disclosure of that, and it was never given. In Bello itself, Mr. Bello was from Nigeria. As at 22 March, which was the last version of the list that we had, Nigeria hadn't closed its borders, but it did so on the 26th of March. It doesn't, and as far as we could see, there was nothing to distinguish Nigeria's closure of airports from, for example, the closure of airports in some of the other countries which were on the list. So it looks like the Home Office wasn't updating the policy. It seems to me there may be a proper issue of legality about that when we get proper disclosure about it. And thirdly, as they announced us the day before the hearing in Bello, they actually ceased to operate that policy as long ago as the 10th of April. I haven't seen anything further on that, but we have seen a letter saying that. All of that means that there's a bit of a lacuna. And in fact, you can see how problematic that is by just thinking about the facts of Bello again for a moment. Because what happened with Mr. Bello is that as I said, on 26th of March, they closed the airports. It was for 4 weeks initially. By the time of our interim relief hearing on the 17th of April, the airports were still closed, but the government was saying, which doesn't seem to fit very comfortably with this kind of policy at all, well, that's okay, because the closure will be reviewed on the 23rd of April, and we'll think again. It's only 7 days, what's the problem? Now, entirely predictably, just as we all know that the lockdown in this country is not going to end the day up just because the government is up for review in 2 weeks' time, entirely predictably, a few days later, Nigeria closed its airports for a further 2 weeks, and I think has done so for a further period of time. And in fact, the airline on which they purported to book a flight cancelled the flight because of lack of demand. So the absence of a policy, a clear central government or central Home Office policy line on this is going to cause caseworkers to make really rather random and unpredictable judgments, it seems to me. That's a problem in terms of consistency. It's a criticism of the government. And it means that you may have to argue the point about legality via Hardy or Singh rather than via any policy. But anyway, that's the position as it appears at the moment. A couple of things to think about that in light of all that. Pressure points, it is the case that a lot of people have been released. As Graham, I think, quoted, it was 736 of 12 remained detained as of late March. In fact, a lot of people have been released since then. I gave evidence to the Home Affairs Select Committee on Thursday, and the session before us had operators of IRCs who were giving evidence to the committee, and they were talking about the numbers of detainees being as low as 20% of their normal numbers. So it's obvious that a lot of people are being released. And what that certainly ought to mean and may mean, for a lot of people, is that the Home Office is going to be detaining only those who are high-risk offenders. And certainly that ought to be the position if you take seriously the series of policies that I've been going through in this presentation. So what then is likely to be argued about? Well, first of all, think about bellow. I suspect that a lot of people may be being detained in circumstances where those policies aren't being applied, and in particular, it looks like the adults at risk level 3 COVID-19 policy, if I can call it that, is simply not been explained, and caseworkers aren't being made aware of it, and detention decisions may be being taken on that basis. I don't know whether they've done anything about that since bellow they've improved matters, but it's certainly going to mean there are strongly arguable historic detention claims for people detained in those periods. Secondly, it seems to me there is a proper real failure by the Home Office, and it's a point that I would like to take forward in an appropriate case, to recognise the cumulative effects of these policies. What often happens is you get a review of the person's detention under COVID-19, which looks only at the adults at risk and COVID-19 situation, ignores their mental health problems, ignores the fact that the EIG may be pointing in favour of their release in any event, concludes that their detention is lawful. 3 days, or is proper. 4 days later, you get a detention review which ignores the COVID-19 policy but looks at some of the other factors. And so again, detention is maintained. So there's a real problem about the Home Office failing to take joined up decisions which look at everything at once and consider their cumulative impact. Thirdly, it's a long-standing problem, I think, with the Home Office decision making in this area, that it just jumps from this person has committed an offence in the past, or a serious offence in the past, therefore this person is a high risk to the public. It should be treated as a high risk case. And that's just wrong, because they may, like Mr. Zallis, have committed their offence 19 years ago. They may, like Mr. Bellow, have been assessed as being low risk by the Mental Health Tribunal or by the NOMS assessment. And so that I suspect is leading the government to detain a lot of people who shouldn't be being detained, or about whom there are, on any view, arguable issues about the legality of detention. And I personally think the observations of Elizabeth Lang QC and now Mrs. Justice Lang in the BA case are really useful on this. She really drums home the point that it's about risk of reoffending, not about the fact of past offending. And then the other problem I've already talked about, I think caseworkers are going to be making kind of wild card and maverick, over-optimistic assessments of whether a person can be returned, because they will be, as the Bellow case illustrates, booking flights for people even though there's no chance of that flight taking off, that sort of thing, and maybe maintaining detention in those circumstances. Last slide from me, and I'll take it quickly because I'm very conscious of we've probably gone way over our time. In terms of tactics, do think about bail. Very high success rates for getting bail in the FTT, anecdotally. So you may want to, if you want to get your client out of detention, think about doing that alongside any detention claim. Secondly, I should have said, there's no bullet point. My experience is, and this married up with what Graham's been talking about, the admin court is really very efficient and very impressive. It is willing to order things urgently. It has a good system for getting things before judges. N463 applications are going before judges on the day, same day or the day after, if you're lucky, and certainly very quickly within a day or two of lodging the claim. And judges are, in appropriate cases, if you can make the case, willing to order both very urgent interim relief and or final hearings. Thirdly, then, back to the bullet point, what should you be going for, interim relief or final hearing? Well, Graham's talked about some of the difficulties of getting interim relief. Obviously, judges are going to vary. My general approach, even before these, is to always go for both. And you can make an attractive case to the judge that basically says, look, you may want to give me one interim relief, or you may want to give me the other, but as long as you think this case is arguable, it's obvious that I should get one or the other. I should be getting either a rolled up or hearing or a final hearing with permission, or I should be getting interim relief. Should you be pressing for interim relief? Well, often I think interim relief in immigration detention is relatively unrealistic, precisely because the court can give an urgent hearing. I think it's a bit more realistic in the world we're currently in. because there is this kind of game changer of COVID-19, and some judges are going to be willing to release on an interim basis, but it's still a big ask. So always be alive to the fact that you may be looking at a final hearing, and then you may be looking at the government conceding it before that final hearing. That may be the way you get your client out in practice. That's what happened in Zales. Think hard about a release address. In the cases I was doing, we had clients with particularly serious conditions, and that meant that they were entitled to support under Section 117 of the Mental Health Act, or by the NHS in some other way. That made life a lot easier, actually. For clients who don't have that kind of support, getting some sort of accommodation arranged may be the big practical obstacle to getting a release order, or even getting the Home Office to agree release. And lastly, and I can see people raising their hands virtually, so I'll shut up after this. I'll just very briefly mention cost issues. Some tricky issues about costs have been happening, where the Home Office is saying, well, costs are, this claim wasn't necessary because we've released, or whether release has been ordered by bail by the FTT. And they've, in the extreme cases, I think Graham has a case where they sought and obtained a no order as to costs, and I think that may be the subject now of an appeal. But there are tricky issues about how far you press depending on what happened, which we can talk about perhaps in the questions. I'll shut up now. Hopefully Graham's on top of some questions, and I'll try and get on top of them as well. Okay, thanks very much. Graham, maybe turn your video back on, and I'll see about
thanks, Tim.
To share my screen.
I hope I'm back on there. Can you see me?
Yeah, you're back.
So I've got three questions, all raising quite interesting points. Fourth one just coming in that maybe you can have a look at while I'm talking through these ones. Two of which I think we can take quite shortly, one of which raises quite complex questions that I don't think I'm in a position to answer, but may be able to cast some light on. The one I'll take first is whether there's any scope in litigating these issues to hold an individual Home Office case owner liable for failures to apply relevant policies in a case. I mean, if I can give a short answer to that, and so maybe if you come in if you've more to add. I mean, I think the short point is that in the JR context, it's difficult to see how that would add any. In the private law context, so after the fact, if you're seeking damages for false imprisonment, or you're bringing a private law claim damages in relation to the circumstances of your client's detention, then theoretically the answer is yes. But my view is it's going to be extremely risky to do it, and it's if you can show sort of breaches of policy by the Home Office, it's unlikely you're going to need to go there in order to make your case. In order to do it, you'd have to bring your claim misfeasance against the individual, and there's a much higher threshold for showing misfeasance than there is for showing public law unlawfulness. You have to show that the individual acted in knowledge that they were acting unlawfully or with reckless indifference to the lawfulness of their actions. It's a tort of bad faith, the way that false imprisonment isn't. And obviously, if you bring a claim in misfeasance alongside a claim for false imprisonment, you lose on the misfeasance claim but win on the false imprisonment claim, you see all sorts of adverse cost consequences. But in circumstances where the misfeasance claim didn't really benefit your client. The other way potentially you could bring it into a claim is you could use it as a basis for arguing for exemplary damages in the context of a claim for false imprisonment. But again, if you're making allegations against a named individual, the court is going to apply quite a high threshold to the way it deals with that. It's going to prolong and complicate the hearing, and you need to think very carefully as to whether the evidence and the potential outcome actually justifies going down that route. I don't know if you have anything to add to that, Tim.
Yeah, I think that's right. So I've sort of come into this halfway through your answers. I've been trying to work out what's going on, but I think the thing about misfeasance is that, you know, people use the reason you may want to use misfeasance is really when you can't think of anything else. And the beauty of, well, whatever else one can say about these cases, if you're in a situation where your client's detained, then you've got a claim for false imprisonment, which requires the Home Office to justify that detention was lawful. Now, if they detained you for an improper motive, it's going to be unlawful. So query what it really adds. you may want to argue misfeasance in the context of arguing about exemplary damages, but again, you can get exemplary damages. If anything, the test is, although it's very high, it's probably lower than for misfeasance.
Yeah, yeah.
So I'm just not sure it would add anything, and certainly it's not a point that I would be pressing at this stage, where you're trying to get your client out rapidly, because I mean, in both Bello and Zallis, we had to think about whether we would press our claim under Article 3. Now, in light of the detention action judgment, it seemed to me it was very hard to do that. That's not to say that down the line, when all of the evidence comes out, people won't conclude that some people were being detained in breach of Article 3 because of the COVID-19 risk. But getting a judge to decide that on the basis of a kind of a virtual hearing in a day, all impossible. And so what we effectively asked the court to do was to stay those claims, because it seemed to me it was just setting a higher target to win on Article 3 than anything I could achieve under the other heads of claim. And it seems to me that would apply equally in relation to misfeasance. Sorry if I've repeated Graham a bit, but as I said, I was just trying to work out where I am. Graham.
Thanks, Tim. So the next point, which again I think can be taken fairly briefly, is whether failing in an application for interim relief before the administrative court will impact adversely on prospects of a bail application to the tribunal. And I think it's impossible to give a sort of concrete answer to that. But given that the factors that the administrative court is looking at on an application for interim relief overlap quite significantly with the factors that the tribunal is going to be looking at on an application for bail, it's likely, in my view, to have some impact. But they're not asking them. They're not sort of jurisdictionally. They're not asking the same question. So the one doesn't rule out the other. A failed interim relief application would not preclude an application for bail to the tribunal, and certainly given the very high rate of success in the tribunal at the moment, I wouldn't say you should simply abandon a bail application, but it may well have an impact on the outcome.
Theoretically, they're different, but in practice, I just think a first-tier judge is going to look and think, well, the High Court judge didn't think he was going to need to be released, so why should I? In theory, he shouldn't do that, because in theory, he should be applying probably a lower test for bail than for unlawful detention. But if one could arrange, you can't always arrange it, but if you can get your case in front of the FTT first, and then in front of the High Court on interim relief, the High Court won't be very influenced by the bail decision, and then at a final hearing. If you can get it in that order, great. If you get your interim relief hearing before your bail hearing, it's going to be a bit trickier, I think. But
I'd agree with that.
Equally, use every tool. If you may just have to do it that way. Use every tool in your armour.
Yeah. I'm sorry. Just another reason to support that approach is that the tribunal quite often grants bail in principle, and a grant of bail in principle can throw up all kinds of really complex issues about accommodation that you may then want to ventilate in a JR. So get as much as you can from the tribunal and then move on to the High Court, I think, would be the appropriate route if it's possible to do that. And then finally, a quite involved question from Frank Arnold, who was one of the medical experts reporting the Detention Action. It's about the route that the Home Office are using to identify individuals who have what's termed relevant comorbidities in the detention action judgment, people who are at heightened risk of suffering effects from COVID-19 infection. He points out, I didn't know that, but he points out that the Home Office are adopting the course of using IS91 RA Part C risk assessment documents rather than Rule 35 reports as the norm. I can't vouch for this myself, but that's his understanding for notifying people who are at risk, and that in his view that raises certain issues, in particular that the IS91 RA Part C is not a form first and foremost designed for the assessment of medical risks. Second, that by taking that route, the IS91 RA document is not copied to the patient, which potentially raises data protection issues. And there's third is that there's no feedback to the author of the document, so there's no opportunity, if this is correct, for the author to take issue with any part of the Home Office analysis in responding to it. And because it's not copied to the individual or their representatives, there's no opportunity for them to correct any mistakes that maybe have made their way into the analysis in the document. So query whether, if that's the route that is being taken by the Home Office, that gives rise to some kind of potential challenge. I think the short answer is maybe, but I can't take it any further than that. But Tim, you may know more about this.
I was about to say maybe too. I mean, the only other point that occurs to me is that, of course, they do have a duty of inquiry as a result of the DAS case, so they've got to properly inform themselves of whether someone has a condition which will be relevant to the AAR policy. Once you've decided that COVID-19 comorbidities are relevant, you've got to make sure you inform yourself. So that might be a way into making that argument, but I don't follow the details at the moment well enough to know whether the challenge is viable. I mean, the other thing I've touched on is that, because it sort of interrelates with the point that I was making, that unfortunately caseworkers aren't being made aware of the relevant policy, i.e. treat these people as level 3. They may be, at the other end of the spectrum, they may not be made aware of their health conditions either. On the other hand, for what it's worth, in 2 cases I did, they seem to have the factual stuff, i.e. this particular individual has asthma, that's a problem. It was the policy, they just didn't seem to be aware of the policy, but there may well be a challenge there. I think there's going to be a distinction between the kind of challenge you can bring now and get your client out of detention now, and the sorts of challenges which I think will probably just be quite difficult to do in 3 weeks at a virtual hearing, where you're looking at the slightly more systemic stuff. I fear that some of that will come later, but it would certainly be interesting to look at it, and there may be some knowledge in it. And it's worth, I mean, the other thing to say about it is it's worth putting pressure on the Home Office about these things. You can raise these points in your pre-action letter. You can, and you won't get a proper response. That's just the reality. And you may, even if it falls short of being a pure ground of challenge, you may be able to make some headway. Well, they haven't told us this, so we've got to work on these assumptions because they haven't responded to our request for disclosure or information about how these policies are supposed to work.
Thanks, Tim. I think just one other question that's been raised that I think we can take quite briefly is whether the decision of the Supreme Court in AM Zimbabwe is likely to have any impact on the way the courts approach Article 3 arguments in these cases. Tim, you've argued Article 3 in one of these cases, so perhaps you might want to comment on that.
I thought you were going to... I'm not sure is the answer. It's not... I think that... it may do. I don't think I know the answer to that at the moment. I haven't had a chance to think it through fully. So back to you, Graham.
I don't know is the short answer, but I suspect not, given that the jurisprudence about the Article 3 impact of removing people in health cases is such a sort of narrowly confined area, and there's an entirely different line of case law about the sort of duties owed under Article 3 in the context of health risks in prisons and so forth. I think there's unlikely to be an overlap, but I don't know the judgment in sufficient detail to really comment.
There may be an indirect impact from that case, because there may be people who look like they've come to an end of the line in terms of their deportation appeal, who may be able to say, well, in light of that judgment, we can open this all up again, and that, of course, will impact on not necessarily immediate legality of detention, but removability and whether they should be being detained in the longer term. But I know that's not the question that was asked, but it strikes me as a point that's worth being aware of.
Yeah. Great, so that's all the questions.
Do we have any other questions? Any more? We seem to have retained a reasonable number of people on the call. Most people on the call, that's good. I hope that was useful and of interest. As I've said at the outset, we will put the slides and the live feed onto the website. Someone mentioned to me earlier today something about a Chambers YouTube channel. I don't know if I've quite understood that rightly, but something like, anyway, it's going to be available online. If you want to go back to it, the slides will be available. We will have a look at, we'll have another look at the questions and just see if we can think of anything in kind of slower time that we can add to that and put an addendum if there's anything more to add. I'm not sure if there will be, given the nature of the questions, but if there's anything further on that, we will. Otherwise, thanks very much, everyone, for watching. We hope you found it useful, and hope you'll be able to make some use of it in bringing cases of these kinds. Okay, if there's no other questions, I can see some thank yous coming up, which is nice. We'll end the session here. Thanks very much indeed. Thank you.
Very much. Take care. Cheers. Bye-bye.